Hi, welcome back to Legal Voyage YouTube channel. Today I thought of discussing with you all the law of prescription in Sri Lanka. Prescription, in other words, means the time bar set out for court actions. Let us see what these time bars are. The applicable law on prescription is found in the Prescription Ordinance No.22 of 1871, and this has been amended several times by the Prescription Ordinance Amendment No.2 of 1889, Prescription Amendment Act No.26 of 2014, and recently it was amended by the Prescription Special Provision Act No.5 of 2016. So if you want as to why we require a law on prescription, it is primarily because it helps to protect a person from having to defend a claim after an indefinite time period. This in turn avoid fading away of memories and also avoid the difficulty to locate documents. Let us see the different time bars laid down by the prescription ordinance. Section 3 of the ordinance states the term of prescription for land and immovable property is 10 years. This means if a person is in possession of your property and if he is in undisturbed and uninterrupted possession for over 10 years, then you cannot take action against them because your action will be prescribed. So make sure if you want to evict a person from your property, you have to do so within 10 years of possession. Section 4 of the ordinance states a possessory action should be filed within 1 year of dispossession. That is, if you are dispossessed of your property unlawfully, make sure you go to courts within 1 year of such dispossession. Section 5 states that recovery of any sum due upon a mortgage, debt or bond should be filed in court within 10 years of expiration of a stipulated time in the instrument, or within 10 years of the date of the instrument, or within 10 years from the last payment of interest, or within 10 years from the breach of the condition in the instrument. Section 6 states that a breach of partnership deeds, written promise, contract, bargain, agreement, security upon promissory note, bill of exchange should be commenced within 6 years from the date of the breach, or within 6 years from the date when such note or bill shall have become due, or from the last payment of interest. Next, Section 7 states an action to recover goods, rent, money lent without written security should be commenced within 3 years from the cause of action. Section 8 states an action in respect of goods sold, shop bill, book debt, or work and labor done should be brought within 1 year after the debt shall have become due. Section 9 states for claiming damages under law of delict for a loss, injury, or damage should be commenced within 2 years of the cause of action. Section 10 states in case of actions not hereinbefore provided for, the term of prescription is 3 years. Section 11 specifically states claims in reconvention will not be allowed where action is barred. Section 12 states no acknowledgement to take a case out of the operation of this ordinance unless in writing. Therefore, this ordinance will apply for any action unless it is exempted in writing. Let us now see some provisos provided under Section 13 to 15. Section 13 and 14 states disability at the time the right to sue accrues, such as infancy, idiocy, unsoundness of mind, lunacy, or absence beyond seas. If for these reasons a person has been unable to come to courts at the correct time, the period of limitation provided will not commence to run until the removal of such disability or death of such person, whichever happens earlier. However, you need to remember adverse and undisturbed possession of an immovable property by a person for a period of 30 years will be taken as conclusive proof of title despite of any disability described under section 13 and 14. This is also called as prescriptive title. Then section 15 lays down the other proviso, which states nothing contained in the prescription ordinance will in any way affect the alienable or inalienable rights of the state. It will not affect any action for divorce, or it will not apply to any case in which special provision has been made to determine the period within which action must be commenced. Is an arbitrator bound by the provisions of the prescription ordinance? In the case of Phil East Asia Construction Corporation versus Garadari Hotels Lanka Limited and another, the Court of Appeal upheld the position that an arbitrator is not bound to give effect to limitations set out in the prescription ordinance. However, when calculating the period of prescription for any action, you should remember not to include the period that elapsed between the commencement of arbitration and its completion or termination. This table gives you a summary of all the time bars that I have discussed. Thank you for watching the video. If it was useful to you, please subscribe and stay in touch for more videos like this. Thank you.